Ah, it's gonna be another mediocre talk by this guy. He just comes and he talks and he talks and he talks and he. Hey, there's some really nice people there. Hey, Mister, you should turn your camera off until you get dressed. Yeah. Uh, oh wow, this is gonna be a very uninsightful talk. It's primarily for people who want to learn about the basics of estate planning, but the presenter will probably mention estate view software 95 or 100 times. And some of the things he says will make your head spin. So I'm going to stick my neck out here and say that if you have anything to do today, you should probably do it instead of this. Nevertheless, let me mention that this program does not qualify for continuing education credit, primarily because it's not good enough. And also, my lips are not in sync because of audio technical difficulties. Nothing to do with the manual dexterity problems of the presenter. In addition, if you have questions, you can go to the question box and you can put your question in the question box, and if I'm around, I'll answer it later when I'm done drafting documents and all the other stuff that I do here. Thank you very much, and I hope that this introduction is much better than the program. All right, Alan, it's time. Okay, thank you very much. Yeah, thank you. All right, welcome to this program. It is entitled Fundamentals of an Estate Plan 102. Last Saturday, Jerry Hesh and I talked about Fundamentals of an Estate Plan 101. The presentation does not qualify for continuing education credit simply because we didn't register it. If you're a CPA or lawyer and you want a certification of attendance, just let me know, and the computer does track attendance. You could go back and watch part 1 of the Fundamentals of Estate Plan 101. You could just Google YouTube Gassman Fundamentals. It's probably right on our YouTube channel, but if you can't find it, let us know. A replay of this webinar will be emailed to you in a couple of hours once Brittany gets around to doing it. Thanks heaven for Brittany. If you're interested in Estate View software, send me an email and I'll be glad to mention it. So I'm going to mention it at least 94 more times during the webinar. The Corporate Transparency Act is on hold. The deadline for non-hurricane residents was December 31st. The deadline for hurricane residents was rolled way back to the summer. A Texas court about 10 days ago declared the whole act unconstitutional, and the Treasury Department has appealed that, but has also acknowledged that the act is enjoined. So all the work we did for you on Corporate Transparency Act compliance, thank you very much for letting us do it. And when the courts find that the act is constitutional, and unless the new president and the Congress eliminate the law, which I don't think would happen, the act is on hold, but it is coming back, Jack. If you'd like a copy of our Asset Protection Trust Handbook for Advisors, let us know. We're very proud of it, and it's getting really good reviews. A lot of what I'm going to talk about today is from our book, 8 Steps to a Proper Florida Trust and Estate Plan. If you're in another state, you could just cross out the word Florida, write in the state that you're in, and 80 to 95% of it will be exactly the same. And I'll walk you through the main parts of that book today, but the book itself is in your handouts. So, it's an old book. I've got to update it, but not all that much has changed. Another Fundamentals of Estate Planning program that I would recommend is Basic Estate and LLC Planning, Fun with Dick and Jane. This you'll find on the YouTube video. It was written for bank personnel. So it was written by law students and paralegals at our law firm to present to bank clerks who don't really know what a will is, don't really know what a trust is. And it goes through pretty well, and it also takes them through the adventures of Dick and Jane. So I'm going to go ahead and open Estate View here and show you some of the questions that we ask a client. We went through these with Jerry to a certain extent. We've advanced the program over the week as we continue to do so, and as I continue to like to see what viewers think about it. But on the first page, those of you who are lawyers understand who is the referral source, and have I kept the referral source informed? Have I thanked the referral source? That's important. And then, of course, the marital details are the same. One thing we're asking now is, do you have a concierge doctor or a primary care doctor? If it is, who is it? So that we can talk about whether you should go to Mayo Rochester and get your medical conditions handled, as a lot of wealthy clients do, or not. That's now on our checklist. And then another thing we added to the checklist under the asset information, and this is basic estate planning, is of course for your vehicles, where is it and who owns it? And it's going to say, wait, why is anyone other than just the owner driving that car? So if the owner is Bobby and Mary, they own it jointly, why would you let Mark drive that car? Don't do that. You should only drive the car. You should own the car that you drive. So I don't want Mary and Bob to own a car. I don't want them both to get sued if one of them is negligent. I just want Bob to own the car and Bob to be the driver. And then who's going to inherit the car? It's good to ask clients that, because some clients want their car to be inherited by a certain person. And then you can also automatically know that it's going to be the spouse. And is it under warranty? Because I forgot that my Porsche warranty was running out. So now I have a broken Porsche and no warranty. So it might be a good idea to track that. And then watercraft, that's a boat. Did you know that if the boat is more than 21 feet, that it will not be covered under your normal liability insurance or umbrella? So we ask, is it over 21 feet? Who owns it? Who operates it? Okay, so on the financial end of things, one thing that's very important in estate planning is beneficiary designations and how the estate plan is laid out. So I'll just close my screen. I'll try to center myself better. Marcia always tells me I'm off center. So let's talk about the basics of estate planning. We do have some people here who are not lawyers or accountants. They're just lucky not to be, I guess. So as part of my estate plan, I'm contemplating knowing where my assets go when I die. That's what estate planning is about from the point of view of most laymen. When I die, I may have assets in my personal name or payable to my personal name. That could be a bank account, that could be my furniture, that could be my legal practice, which is required by Florida law to be owned by a lawyer. When I die, those assets in my personal name make up what is known as the probate estate. What is probate? Probate is the process whereby assets in my name pass to the beneficiaries under my last will and testament by the terms thereof. Okay, so Alan died. Let's go to the funeral. See, oh, pretty flowers. They served lunch. It was pretty good. The wine could have been better. Wonder what happens to Alan's assets. Well, the will says that everything goes to Marcia. So that's nice. Marcia goes to the bank with my will and my death certificate and pretends to be sad and says, hey, I need Alan's bank account. Well, the bank says, not so fast, lady. Under Florida law, you need a court to either issue an order telling us to give you the bank account or appointing a personal representative, also known as an executrix, also known as an executor, to have the authority to give us the bank account. So Marcia says, oh, I didn't know that. My lawyer was a husband. I mean, my husband was a lawyer. I wish he had told me. She goes to the probate court. And the probate court says, sorry, we can't talk to you. You're not a lawyer. And she says, what do you mean? I'm the client. Why can't I represent myself? Why do I need a lawyer? Well, because under the Florida bar rules, you can represent yourself, but not someone else. And Alan's probate estate is someone other than you. So you need a lawyer to represent you in your capacity as his wife. She says, gosh darn it. She goes to a lawyer. The lawyer says, yes, please pay me. I knew Alan. I'm charging you extra. And what we're going to have to do is, if it's a small estate and all the liabilities are paid, we're going to be able to get an order of summary judgment. I mean, a summary administration or a family administration. As long as all the bills are paid, there's not much in taxes and XYZ. Okay, that's good. But if Alan had a large estate, like his ego, and I think it's over $100,000 or something like that, we have to get you appointed to be the personal representative. And then, oh, before we can do that, we have to get you bonded. You have to fill out the bonding application. Then the judge will set the bond. Then the judge will appoint you as personal representative. Oh yeah, we have to give notice to all your children and adult grandchildren and anyone else who's named in the will. Okay, oh, we need them to consent or go by certified mail. All right, we have to file that. Okay, the judge appointed you after 2 to 4 weeks of delay. Okay, now you can go to the bank and get the money. But now you have an obligation to inform the court of all liabilities, all assets, et cetera, et cetera, et cetera, et cetera, take an et cetera. It's a lot of work. If only Alan had had that bank account payable on death to Marcia, then on his death, she would have just been able to go to the bank with the death certificate and they would have given her the account. So that's a pay on death account to avoid the pain of probate. And what about that little rental house that was in my name? Well, first of all, it shouldn't have been in my name. That's terrible asset protection planning, but it was in my name. Well, that's got to be probated too. Well, what if that was a little $10,000 cabin in Washington State? Okay, now you need two probates, one in Florida and one called an ancillary probate in Washington State. Oh, and you need a lawyer in Washington State to help you with that. Well, what's a ladybird deed? When Lyndon Baines Johnson was the president of the United States, he was the vice president under John F. Kennedy. When John F. Kennedy got shot, JFK gave a little speech that said, all I have, I would have gladly given not to be here this day. That's a great speech he gave. Well, eventually he had a bad day. He died, I think in his 90s, and his wife was Lady Bird Johnson. And I will tell you that my mother waved at Lady Bird Johnson at the Apollo 11 launch, and Lady Bird Johnson waved back. And then the FBI asked my father who he was and why Lady Bird Johnson was waving at my mother. And the reason was my mother shouted out, I'm from Texas too. Anyway, now that you know that history, LBJ had a ranch that he wanted to go to Lady Bird when he died. So he executed a deed And the deed said, this is my ranch and only my ranch, and I'll keep this ranch, and I'm the owner of this ranch. But on my death, if I don't change this deed, it will go to my lovely wife, Lady Bird. My mother was not mentioned in this deed, by the way. So when he died, Lady Bird got the property. So that is the Lady Bird deed. So if I only have a bank account and a property, which is what a client of mine has, his father rather has a house in Texas and a bank account in California, and I just told him, let's do a pay on death account and a ladybird deed. He said, well, what's a revocable trust? Shouldn't I do a revocable trust? Okay, let's talk about revocable trusts. When I was in high school, my father bought the book, How to Avoid Probate by Richard Dacey. And it was a big book, and I read it in 10th or 11th grade, and maybe that's a reason that I'm an estate planning lawyer, because the Dacey book, How to Avoid Probate, had forms that my father and I filled out so that he and my mother could avoid probate. And how did that work? It was the Dacey Trust, of course. Under the law, going back to England, well before 1776, even well before they filmed the movie Spamalot, you could set up an agreement, a contract between a settlor, also known as a grantor, who sets up a trust and puts something into it, a trustee who holds the asset, and one or more beneficiaries, those lucky dogs who are going to be the beneficiaries of the trust. It's a three-party agreement. It's called a trust. It's not actually an entity. A lot of people would say, I give my dog to the ABC Trust. You're really giving your dog to the trustee of the trust, who is supposed to follow the terms of the trust, which may be tickle my dog, pet my dog, bathe my dog, take care of my dog, etc. That's called a pet trust. So there's two basic varieties of trusts. One is a revocable trust, which I could change, and one is an irrevocable trust. So Dacey popularized the revocable trust. He said, instead of Marvin Gassman and Sarah Gassman owning their house, they could form a trust, and that trust could own their house. They could own that house as trustees of the trust, and that trust could say that on their death, the house would go to their children. And then on death, instead of going to the probate court, you would just show the title company or whoever wants to buy the house that the trust agreement owned the trustees own the house, and the trust agreement says that new trustees come in and can hold or convey the house based upon the terms of the trust. So that's the revocable trust. Now, of course, people prefer not to go through probate, although the advantage of probate is the judge makes sure everything gets done right. If you leave assets in a trust, you would hopefully appoint a trustee who's going to do everything right, because there's not going to be a judge overseeing the trustee of a revocable trust until one of the beneficiaries files a lawsuit, which is a different story, which we'll probably cover today a little bit. So now I could form a revocable trust, and I can put my rental house in Washington State and my bank account in that revocable trust. And on my death, I could have Marcia as the successor trustee of that revocable trust. And when she dies, when I die, she walks into the bank with the death certificate, and they look at the trust, they look at her, they look at the trust, they look at the death certificate, they look at her, they go to lunch, they come back from lunch, they talk to their home office, and then they allow her to take over the account after she gives them a new tax ID number. See, it's not as easy as the pay on death account, but it's relatively easy. people don't have problems with it. There's another advantage of the revocable trust, besides the advantage that I can charge more for a revocable trust than just a will. The other advantage of the revocable trust is I could put other assets in the trust, and if I become incapacitated, even more incapacitated than I am right now, to the point where I could not manage my own situations. See, I'm not going to say my own affairs because Marcia watches this. My own situations, I can't manage them. Then instead of having to rely upon a durable power of attorney to get hold of my house in Washington and my bank account, Marcia would be the alternate trustee. Now, a durable power of attorney, at least in Florida, can work pretty well while you're alive. And if your durable power of attorney says that your agent can establish a trust, then what happens sometimes is the client comes in and says, oh, my husband is incapacitated and he can't make any decisions, but I'm the agent under his power of attorney. What should I do? And sometimes we'll say, well, let's establish a trust for him. Does your durable power of attorney allow you to establish a trust for him? In Florida, if the power of attorney was signed after 2011, you had to initial a certain part in order for you to be able to establish a trust for somebody who's incapacitated. By the way, if you become incapacitated and you have to have a guardianship appointed because you're running around doing all sorts of crazy things, so somebody finally gets a judge to declare you incompetent, then your power of attorney normally loses effect in most states. I hope I'm not causing a state of confusion. So you've got a last will and testament, and you've got a revocable trust. Now you're saying, what happens if my last will and testament says that upon my death, the assets in my name will form a trust, and that trust will be held, say, for the health, education, maintenance, and support of my spouse and descendants? Well, that is called a testamentary trust. I don't know how many times you can say testamentary at the same time, but testamentary, 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 testamentary trust would be 4 times as good. The problem is, in order to get the assets out of your name into the name of your testamentary trust, they have to go through, you guessed it, probate. Whereas if you had those assets in your last will and testament, they don't have to go through probate if you have them titled in the trust. A couple other things I want to mention before I forget to mention them. One is, a lot of you are lawyers. You have a law firm that you may own. On your death, it's going to go through probate. My suggestion is that you sign a document called a conditional assignment of PLC or PA stock. It says, in the event of my death or incapacity, the person in possession of this document may deliver it to the successor trustee of my living trust, and upon delivery, the successor trustee of my living trust will own that corporation. See, it would break the Florida bar rules for some silly reason for me to transfer the stock of my professional association, called a PA in Florida, has nothing to do with amplification, although we do talk loud. That would violate the Florida bar rules. But when I die, there will be a violation of the Florida bar rules. Technically, when a lawyer dies, there's no longer a lawyer owning it. The Florida bar, or the bar of any state that I'm aware of, doesn't really care whether it's owned by the personal representative of my estate or the trustee of my trust. So on my death, Marcia can change my PA to a regular company or keep it as a PA. She can be the owner long enough to wind up that professional association or sell it. and that's a whole nother subject. But a lot of times we have physician clients who die, CPAs who die, dentists who die, and we have to do a probate because they didn't know to do a simple conditional assignment of stock. The other thing I'll mention is that we typically do not put cars into revocable trusts because insurance companies don't understand them. Department of Motor Vehicles doesn't necessarily understand them. At least in Florida, you do not have to probate a car. You take the death certificate and a certified copy of the will to the tag and title people. In Florida, you make an appointment before you go. They're very nice when you get there, and especially if you bring them cookies. And then they will allow you to transfer the car. I do say tongue in cheek, but if you try to do that and for some reason they won't let you, just make another appointment, go to someone else the next couple of days, and then they probably will let you. There's two ways to own your motor vehicle. One way is individually, that's what I recommend. But another way in Florida is jointly and Alan and Marcia. What I don't like about that is if one of us is in a terrible accident, the other may be liable. But but if it's and in Florida, if one of us dies, it has half of the house owned by half of that car owned by me has to go through probate because it was Alan and I die and Marcia goes to with the title and they go, wait a minute, Alan was a half owner. It was and. So what's better is Alan or Marcia. But if it's Alan or Marcia, then it's not a tenancy by the entirety's asset. Under Florida law, Delaware law, Wyoming law, and certain other states, if a married couple owns an asset as tenants by the entireties, then if somebody sues one of the spouses, they cannot reach into the tenancy by the entirety's asset. That also applies to real estate held in a tenancy by the entirety state. So you live in New York, you buy a vacation home in Florida, you put it into tenancy by the entireties with your spouse, and then something terrible happens, you get sued, they sue you, not your spouse, and you go into bankruptcy. The bankruptcy code protects tenancy by the entirety's assets, and your creditors can't reach it if there's no debt on the property. I went way too fast for those of you who are laymen, not lawyers or accountants or mother-in-laws who know everything. So the key point is that I want to emphasize is that when you do estate planning or when you have had estate planning, it's not only signing the documents. I mean, signing the documents is important and getting them signed correctly is important, no doubt. But once I sign my will and I sign my trust, and Marcia signs her will and signs her trust, who is the beneficiary of our IRA? Who is the beneficiary of our pension? Who is the beneficiary of our life insurance? All of that is vitally important. And I'll give you a few tips on that. With IRAs and pension accounts, you usually make the beneficiary the surviving spouse. Unless you have children by a second marriage and you're afraid that that surviving spouse is not going to allow those assets to go to the right place, or unless you're afraid of undue influence or the surviving spouse doing not so smart things, you make it payable by beneficiary designation to the spouse, because the spouse can roll it into his or her own IRA and then take it out under the very generous minimum distribution rules that apply to a surviving spouse. And they can take it out even slower if they marry somebody more than 10 years younger than them. That's called a trophy spouse. So a lawyer goes to a bar, and he actually goes to a social event. You can't say goes to a bar anymore. And at the social event is his 85-year-old client and a really really attractive female. And he goes and says, "How are you?" "I'm fine, I'm fine. This is my wife, Melody." And he says, "Well, it's very nice to meet you, Melody. You have a very, very outstanding husband." "Oh, thanks, I know that." So then the 85-year-old goes to the bar to get a drink, and the lawyer goes and says, "That you weren't married when I did your estate plan. You need to come in and update the estate plan. But I just have to ask you, how did you get such a young and attractive wife? She's beautiful. She seems very nice." And the client says, "Well, I lied about my age." And the lawyer said, "Well, I know you're 85 or 86. You told her you were 75 or 76?" And the client goes, "No, I told her I was 91 and in very poor health." So, uh, sorry if you didn't like the joke, but you may consider it a dating strategy as well. Anyway, what's really important about that story is that the lawyer may have said after that, "You need to come see me, because have you ever heard of the homestead inheritance rights or the elective share?" "No, I haven't." "Well, what's the homestead inheritance rights?" "Well, under Florida law, the Florida Constitution, going back to the 1800s, when a person dies with the homestead in their sole name, not in their shoe, but in their personal name, their sole name, if they are married, the surviving spouse can elect to receive their choice of 1/2 ownership of that home or a life estate." It used to be you would only get a life estate. A life estate is, I have the right to live in this home for my whole life. I'll maintain it. If I rent it out, I'll get the rent. And finally, when I die in 96 years, your children will get the remainder interest. Now, the Florida law allows the surviving spouse to elect to receive 1/2 of the house. Now, that would be the top half or the bottom half or the left half or the right half, or an undivided 1/2 interest. And then the spouse could file a partition action and force a sale of the home on the courthouse steps, share the home with the spouse, with the children share the proceeds with the children. So the lovely person at the party that the lawyer met on the death of this 86-year-old client would be able to get half the house. The other thing that she would be able to get on the death of the client would be 30% of his elective share estate. I'm not going to go into details on the elective share estate, except to say that the client could execute a trust agreement or a will that says, on my death, if my spouse makes the elective share election, then in lieu of a flat 30% going to her, 37% will go to a trust for her lifetime benefit. She'll get what she needs for health, education, maintenance, and support. She'll get at least all the income. And what's left when she dies will go back to my children. And I hereby appoint Attila the Hun in Siberia to be the trustee of that trust. So these are things that when I helped my dad write the will when I was in 11th grade using the How to Avoid Probate book, we didn't know those things. So we didn't know about the Florida Constitution and homestead. It wasn't in his book. So, and by the way, when you go into the bookstore and buy a form for a durable power of attorney in Florida, and you go to any bookstore or you buy them on Amazon, if they are not Florida specific, then they are incorrect. Because in Florida, a durable power of attorney has to set out everything that you want the agent to be able to do. That's why our durable power of attorney form is like 35 pages long. And then for 7 of the things that you might want the agent to be able to do, such as change your IRA or set up a trust for you, you have to initial. And it's not enough to say, I hereby initial that I want all 7 of them. You've got to initial 7 times. So there's a lot of people out there in Florida with powers of attorney signed after 2011 that aren't going to do what they think they're going to do. So that is a brief overview of estate planning. The next part, the next thing I want to make sure that I mention is asset protection planning. Now, there's a lot of confusion over what is protected in an estate plan. And what we like to do and what we should do is explain to a client, here are what assets a creditor can reach if you don't have enough insurance or any insurance to cover a liability situation before the planning, and here's what they can reach after the planning. In most states, there's not a lot that you can do. A few states like Florida, Michigan, and Texas have an unlimited liability, an unlimited value of homestead if it qualifies under our rules that a creditor can't touch. In most states, a 529 plan that you might set up for your children or nephew or niece or friend are creditor proof. IRAs are creditor proof. And in many, many states, annuity contracts and life insurance policies with cash value are creditor proof. In a few states, as I said, Florida, Delaware, Wyoming, and a handful of others, if the married couple owns assets jointly as tenants by the entireties, which is a form of right of survivorship, then the creditor of one spouse can't touch it. If you set up the account wrong, though, even though it's joint with right of survivorship, it won't qualify as tenancy by the entirety. So you really, unfortunately, just about need a lawyer to make sure it's done right, unless the account has a box to check called tenancy by the entireties. I do a lot of creditor protection work. I've written a book on creditor protection. So a month doesn't go by that I don't have a new client with an unfortunate story. I feel like an emergency room doctor who sees all these skateboarding incidents, and then he won't let his children have a skateboard unless he doesn't like them, and then he gets them a skateboard. But my recommendation is that you have plenty of liability insurance for what you do, and that you own your assets in a way so that they are creditor protected. The challenge with that, for example, the situation of me and Marcia, which she will tell you has many challenges, but if we put all of our assets jointly as tenants by the entireties for creditor protection purposes, on my death, I don't want her to get all of the assets outright because it's not good tax planning. For estate tax planning purposes and for creditor protection purposes, after I'm gone, we can leave up to $13,610,000, and it will be $13,990,000 into a trust, which Marcia could be the trustee of. She can benefit as reasonably needed for health, education, maintenance, and support. It'll never be subject to estate tax. It will grow at, I hope, 7 to 8% a year on average because we have a conventional investment portfolio. So when she dies 20 years later, if it doubles twice in value, it goes from, say, 10 million initially to 20 million to 40 million, estate tax proof. Next husband can't get into it. So, but if I own everything with her as tenants by the entireties, that's not going to happen. She's going to own it. Now, I could put what's called a disclaimer provision in my will or trust. Now, this is a little bit advanced, but I think you should know what a disclaimer is. And you do know what a disclaimer is because you've seen them. We hereby disclaim. What does that mean? Well, Marcia has the right after my death to be the owner of all of our tenancy by the entirety's assets. And also, let's say my trust leaves her uh, the uh, the $10,000 account. Under Florida law and the law of most states, if not all states, Marcia has 180 days to accept what she is inheriting or to disclaim it. Disclaim it means renounce it. I know I'm inheriting it, but I don't want it. So what happens when she disclaims it? It's considered under the tax law and Florida law to have never passed to her, and it goes to the alternate beneficiary. So if it's my bank account or our tenancy by the entirety's assets, and Marcia had not survived me, where does it go? You look in my last will and testament. My last will and testament says I leave everything to Marcia, but if she disclaims it, then it goes to a bypass trust for her lifetime benefit. Then I explained to Marcia, if I die after celebrating, go to a lawyer and get them to draft a disclaimer document, disclaim Alan's half of the joint assets that would pass by right of survivorship. They'll go through probate, so the lawyer can make a little bit of money. Nothing wrong with that. And then the will pours it into the family trust. Easier done than said. I mean, easier said than done. Jeffrey Pinnell, who's a wonderful professor, semi-retired, has said many times, it's great to plan for a disclaimer. Good luck getting the surviving spouse to disclaim. It is, it's a terrible emotional time. I should mention that many surviving spouses are in a deep funk for months, if not years. It's a tough thing to do at day 180. So it's something that should be talked about in advance. The alternative for many married couples that most planners don't think about or know about yet is the joint exempt step-up trust. So instead of me having a revocable trust and Marcia having a revocable trust, my trust says there'll be a bypass trust for Marcia if I die first. Her trust says there'll be a bypass trust for me if she dies first. If I die, my assets and my life insurance, if I have the right beneficiary designation, pass to the bypass trust for her. She dies first. Her stuff passes to the bypass trust for me. There's an income tax step up. And what do I mean by an income tax step up? If I die owning IBM stock, I paid $10,000 for it, it's worth $1 million now. If I sell it while I'm alive, I'm going to pay a capital gains tax of $990,000. If it's sold the day after I die, there's no capital gains tax. It takes a new income tax basis on my death. Marcia and I, so if I die first, my assets get the step up, Marcia's assets don't. But if we put together a joint exempt step up trust, it is my belief that this joint trust, which is not a tenancy by the entirety's trust, it's not a joint with right of survivorship trust, it's a somewhat complicated trust, but it enables all of the assets of the trust to get a new fair market value income tax basis on the first death. It does this, for those of you who are attorneys, CPAs, or sadomasochists, it does this by giving the first dying spouse a power to direct all of the trust assets to creditors of my estate, but only with the permission of our next door neighbors. And under Internal Revenue Code Section 1014 and the Treasury regulations thereunder, if you have a power to appoint trust assets to creditors of your estate, then even though it can only be exercised with the consent of what we call a non-adverse party, then those assets are considered as owned by the person who died and get a full step up, as long as the assets are not going directly back to someone who gave them to the power holder within 1 year. See, I say lawyers, CPA, or sadomasochists to cover all this. The jest is designed to not come back to the surviving spouse, but to instead go to a trust that benefits the descendants unless trust protectors add the surviving spouse to the trust agreement. That's the safest way to do it. The second safest way to do it is just to have the surviving spouse be the beneficiary of the trust, but not have the ability to receive assets except as reasonably needed for health, education, maintenance, and support. But that's the just trust. So the consumer in most states has these choices. Choice number one, ownership jointly with right of survivorship, maybe as tenants by the entireties. Choice number two, let's split these assets up. Choice number three, a joint revocable trust that may qualify as a tenancy by the entireties, creditor protected trust. Number four, separate revocable trusts. Number five, a joint exempt step-up trust. So, maybe the discussion of what kind of trust you should have is more important than the drafting of the trust. Certainly, that discussion may cost a little bit of money because you're talking to a professional. I do have a Florida Bar Journal article that covers all of this. I think it's in the handouts. Otherwise, I wrote it with Brock Eckstein. So probably if you Google Gassman, Brock, B-R-O-C-K, Trust Systems, S-Y-S-T-E-M-S, the Florida Bar Journal article comes up. And I thank Brock Eckstein, who's now studying for his LLM degree at the University of Florida, go Gators, for his patience in all the darn footnotes that are in that article. So now the next thing that I'll discuss, and it's interesting because I'm looking at the people attending here, and many of you are clients who have these things or have considered these things. So I'm covering the things that we've spoken about before, and now you can ask me a question for free for a change. I don't leave assets in my estate plans directly to children, grandchildren, spouses, or anyone. Because by my experience, if you leave someone a inheritance directly, they can lose it to doing dumb things, or a creditor, or a spouse in divorce, or federal estate tax. So if I was going to get an inheritance, I would much rather it come to me as trustee of a trust to be established on the death of the person leaving it to me. And by the way, if any of you on this webinar would like to leave me as beneficiary of a trust, you've got my name there on the bottom left-hand side of the screen. If I inherit as trustee of a trust where I have the right to receive what I reasonably need for health, education, maintenance, and support, then I can't lose the assets in the trust to a creditor ever, or in a divorce. So that's called an inheritance trust. And I have articles on inheritance trusts. A lot of clients come to me and say, well, I'd like to have an inheritance trust, but my mother is 92 years old and she and her lawyer will never understand an inheritance trust. I've asked her lawyer to draft an inheritance trust and he says she doesn't understand it. Well, assuming that she's mentally competent, I have the client hire me to draft an irrevocable trust on behalf for the benefit of my client. It's called the John Smith Inheritance Trust. John Smith is the beneficiary, he's the grantor, and the trust agreement says this trust which will have $10 in it, may receive inheritances and gifts from my beloved mother or anyone else who would like to give anything. And then we ask his mother's lawyer if the mother's lawyer would be so kind as to simply amend the mother's will or trust to say anything that would go to my son, John Smith, will instead go to John Smith as trustee of the John Smith Inheritance Trust, dated January 23, 2025. That gets done. Then when the mother dies, the asset goes into the inheritance trust. So I think that's something worth thinking about. Now I'm going to look at some questions here. I've got 10 minutes left. It seems like I may have to do a part 3 here, but I feel like I covered most everything. Arthur, how do you get last week's Saturday recording? First of all, you should have gotten an email last Saturday sometime in the afternoon that had that recording, or you can go to YouTube. It should be there. Arthur would like a handbook. I'll make sure to send Arthur a handbook. Okay, Judy. If your house is in an inherited irrevocable trust and you want to sell it, would you need to take it out of the trust and put it in the owner's name so that the home ownership capital gain exemption could be used? No. If I die and I leave a house in trust for my daughter, it gets that exemption when I die. But you make a good point, Judith, and I hadn't thought of this. Now my daughter is using the house. She doesn't sell it right away. She moves into that house. And then in 20 years, that $500,000 house is a $4 million house. When she dies, there'll be a step up. But what if she wants to sell it? Can she use her Internal Revenue Code section 121 exemption? For right now, it would be a $250,000 exemption. So that would be less capital gains tax. Well, I think it's 2 years before she sells it, you could make that trust what's called a Section 678 trust. But you do make a good point that if I leave the house directly to my daughter, then when she sells it, if it's been her primary residence, she'll get that $250,000 exemption. If I leave it in a trust, then some fancy stuff has to happen to get her that exemption. So you all see how tricky this estate planning is. I could speak for hours and hours, and probably seems like I've been speaking for hours and hours. Al, thank you so much. Would you like to evaluate the Estate View software? Of course, just send me an email and we will enable you to do this. Okay, the amazing Chris Rowe, I'm honored that you're watching this webinar. You are certainly a scholar and a great professional. How are assets owned by a joint revocable trust under Pennsylvania law considered for asset protection purposes? I wish I knew. I'd have to research that. I know Pennsylvania, at least for some assets, you have tenancy by the entireties, but I'll get back with you. Stuart, thank you for attending all these webinars. You're a high attender. I mean, you attend a lot of these. I don't know if you're high or not. Do you draft the trust to be created in a, okay, so yeah. So a asset protection trust. So here's another, and this goes into well above 102, right? But one thing I could do especially if I'm single or if I'm married and I think we'll both be sued, is you can draft an asset protection trust, which is an irrevocable trust for your own benefit. In most of the states and jurisdictions, if I set up a trust for my own benefit, even though it's irrevocable, a creditor can reach into it. But asset protection jurisdictions, including Nevada, Delaware, Alaska, and South Dakota, which are the 4 that we have used, do not allow creditors to get in. Now, it's a question as to whether Florida law or Nevada law would apply. If there was an issue, the law is not clear, believe it or not. And you could make the alternate trustee of this Nevada trust a Nevis Trust Company, and that's where it could end up. But the question that Stuart asks is, do we draft trusts in those jurisdictions? And the answer is we do, because we've studied those jurisdictions very carefully and we feel competent to do that. We do not hold ourselves out to practice law in those states. We don't do anything to attract clients in those states. We don't have offices in those states. But under the bar rules and the rules of those states, you don't have to be a lawyer in that state to draft the trust. You have to be competent. We've had lawyers in those states review our trust documents, so we believe we know what we're doing. And in a big or complicated situation, we will have a lawyer from one of those states take a look. But I hope that answers your question. Okay, James wants to know, do funds from a 401k plan rolled over into an IRA that has no other funds in it carry over the unlimited protection from the 401k? It depends on the state. In the vast majority of states, it does. But if you're in a state that does not protect IRAs, then the 401k protection doesn't apply. Now, the bankruptcy code also provides protection for IRAs, but it is not unlimited. Okay, another question from Arthur. One more thing. How can a man who is married and wants to purchase a new home with his wife protect himself if the wife decides to divorce him and take the assets? Well, something I forgot to mention is the homestead right in the Florida Constitution, the homestead inheritance right, can be waived by the spouse by a waiver. It needs to be signed in front of 2 witnesses and a notary. The elective share can be waived. If you're already married, you need a full disclosure of assets to get a waiver of the elective share. And you can have a prenuptial agreement that protects you as well. What did the sea say to the shore? Nothing. It just waved. I hope that's not the best joke of the day. Okay, Arthur, the husband is a doctor. Okay, but I didn't get the whole question, and I apologize that my proficiency is not so. Oh, let me see. If the wife decides to divorce him and take everything, maybe he deserves it. But she would only be able to take 1/2 of the marital assets and 1/2 of the growth in non-marital assets, et cetera, et cetera. Okay, thank you, Chris, for thanking me. Okay, I'll go back now to estate view because I've answered all your questions and the rest of you are sleeping. And what I can do on estate view is I can go to results. So I filled in all the information for these people, and then I click on results. The computer does about 50,000 calculations. Most of them are Monte Carlo, and it gives me a lot of results. And one of the results it gives me, and I covered these last week with Professor Hesh, it tells me the family tree, which is nice. Tells me who their contacts are, or if they wear glasses, it tells me if they wear glasses. Then it tells me their required minimum distribution, how the required minimum distribution rules work and what their IRA may earn. It tells me what the rate of return might be on their investment portfolio using a Monte Carlo arrangement. And of course, we have calculators for each of these that goes into more detail. It tells me what might happen if they do a qualified personal residence trust. Yada, yada. It tells me yada and yada. It gives me their estate tax planning. So I could cover this for a couple of minutes because I don't think I did it with Jerry. And we have 1 minute left. So if they both die, which would be sad this year, they have a $4 million estate tax. But if the life expectancy of Bob is 21 years, Mary 26 years. So a $47 million estate tax projected. So instead of leaving everything to Mary on Bob's death, he can leave a bypass trust with the maximum amount that passes estate tax-free, which is predicted to be 14 million. That assumes that the exemption goes down to 1/2 in 2026. I don't think it will, but we're going to use a worst case scenario. So the estate tax is down to 45 million. But this is where it's important to think about how you're going to fund that bypass trust. And also, how are you going to have your life insurance owned? Because if your life insurance is owned individually, then it's going to be subject to estate tax. If it's in a life insurance trust, then it is not going to be subject to estate tax. If I leave $10 million to Marsh in a bypass trust for Marcia on my death, then all the growth is going to be out of my estate for estate tax purposes. If I leave it to Marcia, she'll get my entire 13,610,000 allowance, but it won't grow with inflation. So she'll pay a lot more estate tax. And you can see that here, 47 million versus 45 million. And that's if the death happened. And that's only if she survives me by 5 years. If she survives me by 15 years, it'll be a lot bigger difference. There's something called a qualified personal residence trust for wealthy people who have estate tax issues, which will further reduce the federal estate tax. You can make annual gifts of up to $18,000 a year per child, and that's going to $19,000 January 1st. So a little gifting trust for these people ends up putting $6 million in that passes estate tax free on the second death. If you gift discounted LLC interests, that goes to $8.4 million in our example. Life insurance trust didn't help these people because it was a term policy and he died after the term ran. So it actually hurt a little bit to do a life insurance trust for term life. Let's talk about term life. I think that's what I'll end on. Here we have a situation where with the instant plan mode, I can change the scenario to add life insurance. So if you're going to add life insurance, it's much less expensive to add term insurance, you see the rates here, than to add a permanent policy. But a permanent policy will still be there if you die. Now, these rates are just typical universal life rates. We're going to be adding something called guaranteed universal life, GUL, which is less expensive but does not develop a cash value. One thing I want you to remember, though, when you go and you get term life insurance, you can file an informal application in a lot of cases. If I file a formal application for life insurance and the test comes up with a little blip on that EKG or a little bit of THC in that blood that the carrier may not like, then if it's an informal application, it does not get reported to the Bureau. If it's a formal application, it gets reported to the Bureau and it's with the Bureau 8 years. So if you deal with an agent who can do an informal application, that's better. Secondly, I can't tell you what your life insurance will actually cost. And by the way, I don't sell life insurance. I can only tell you what might be a typical cost. But if you're going to use the Estate View instant plan program, once you decide, okay, I think this person's probably a standard, and I'd like to know what it would cost to add life insurance. Oh, I see it's $10,297 for a 20-year term policy. I think I'll add that because his children will probably be done with college by then. They'll have more savings. So just click add policy, and then there it is, and you can decide if it's going to be in a life insurance trust or not in a life insurance trust. And then you can re-click on results. And when you re-click on results, you should see a larger life insurance situation. You should, but you didn't. So I have to talk to Kevin and see why that aspect isn't working while this is still, which is why this is still in beta mode. Okay, I have I've gone over my time by 4 minutes. I hope that you have enjoyed this presentation. If you have any questions, comments, or suggestions, and anything you'd like to see on Estate View, which of course has been a passion and a big project for me, please let me know. And then I've got one more question from Julio, and that is, does the Florida Community Property Trust differ from the GEST? Yes, it does. I should have mentioned, and I meant to mention, that under the law of many states, most notably California, Texas, and Wisconsin, because they're the biggest ones, I believe, and Nevada, there's something called community property. And the community property rules say that when one spouse dies, the survivor gets a step up on all assets, which is really neat. The downside of the community property in most states is that if one spouse is sued, all the community property can be lost. So a lot of times we suggest that our clients in California, Texas, Wisconsin transmute out of community property and use the GEST trust. The Florida legislature, I think a couple of years ago, we've written articles on it, you can find, enabled people to set up a community property trust where people, even if they live in New Jersey, I'm not telling you that I don't like people from New Jersey, but even if you live in New Jersey, you can set up a Florida community property trust. You need to have a Florida trustee. And then if one spouse dies, we declare it to be community property. There is a statute that says that any community property gets the step up. The IRS pamphlet on community property says that they take no position as to whether a community property trust in a state like Alaska, which doesn't have community property otherwise, or which gets a little complicated, but the IRS has never said that you get the step up. Now, my friend and mentor, Jonathan Blotmacher, and also Howard Zaritsky, believe that that step up is pretty much in the bag. So it is a higher chance of the IRS approving the step up than with the GEST trust. But the community property trust has a number of requirements that the GEST trust does not have. You should consider both of them, and they're both discussed in our article. And once you've discussed it, then you had discussed it. Thanks again for attending this webinar. We welcome questions, comments, and suggestions. My email address is agassman@gassmanpa.com. I'll go ahead and show you my PowerPoint deck again. So if you have any questions, it's agassman, AGASSMAN, @gassmanpa.com. Thanks again for attending, and may the rest of your day hopefully be so much better than this webinar. Thank you. That was not very good, Alan. Thank you. That's why we call you a dummy. I know. Okay, thank you. End it.